plug in for the Aurora Sportsman's Club also when you got a chance.
Okay, let me make notes here.
Yeah, that's all right. Hey, we're live now. Hey, everyone, we're going to get started in just a couple of minutes here. We're just going to let some people filter in. For all of you who are joining to geek out with us, thank you very much for joining us. And let me introduce to you all Todd Vandermyde from Freedom Steel. He is a good friend of mine and also my absolute go-to guy for Illinois. And Todd is a warrior out there and was actually in the courtroom yesterday. So we're going to use his expertise and his observations and kind of educate all of you about what's going on. So we're just going to give it a couple minutes. Todd and I might BS here for a second, but then, and if you guys are making sure if we got any audio or video problems, please put something down in the comment section so we can make sure that we are actually effectively communicating with you. Todd, thanks so much for being here, buddy.
Hey, great to be here, dude. Glad to do this. It's,
I'm glad to have you on. This is the first time on the channel, but you and I have collaborated, just so people know the background. You and I have collaborated on a lot of things, and I will tell people that oftentimes when there's an Illinois ruling, Todd will be the first to send it to me, but he will send me his highlighted copy, which I really appreciate, because even though you're not a lawyer, and I've told you this privately, your ability to break a case down and to analyze case law is remarkably good. And I'm always amazed that when I go through your highlighted opinions, I'm like, yep, that's the points to be taken from this. So you don't, it's a real skill set. I think you missed your calling. I know you love moving dirt and all of that stuff, and you're good at that, but I think you missed your calling, man.
Yeah, I'm at 6. I'll be 61 in a couple of weeks. I'm just too old to go back to school. Just not gonna do that. Although, I mean, I had two main goals yesterday: to watch, to make sure we got there in time to get a seat in the courtroom, and to be not found in contempt of court. But then I would have represented myself in front of, well, let's have my hearing right now. Let me tell you why I think you're a fool.
Yeah, or you might have used other more colorful language because if you're going down the contempt road, go ahead and get your money's worth out of it, All right. Hey, listen, it is 9:30. I want to welcome everybody who has tuned in already, or all of you who are just joining us right now. My name is William Kirk. I got a channel called Washington Gun Law. With me is my good friend Todd Vandermyde. He's got a channel called Freedom's Steel. He is my absolute go-to guy for everything Illinois, especially in the legal field. He has been an absolute warrior out there, been a lobbyist, and actually is also the president of the Aurora Sportsman's Club. And I have had 2 opportunities now to be out there and check out that amazing facility. And while we got you on, Todd, why don't you go ahead and put a plug in for that amazing facility you got out there?
Sure. If you want to check us out, the website is aurorasc.org. We are the largest gun club in Illinois. We're over 300 acres and 3,000 members. And we have the closest 600-yard range to Chicago. And we have elevated shooting platforms on the 600. You were out there when we were building our new elevated platform, 4-story elevated platform on the new 200-yard complex. We have, a 40-position dedicated bullseye range for those leagues. Our action director just told me that in 2026, he currently has 105 events scheduled.
That's awesome.
Those are matches. Those are everything. And we just opened up our live fire shoot house. We have
which I've been through with you, which is pretty darn cool.
Yeah, we have our DOD qualified. It was built by DOD contractors. And it's one of the few, we're probably one of the 2 gun clubs in the country that have a shoot house, a real shoot house. And we are probably one of the very few that allow civilians to go in there for training. And we have some
myself included.
Yes, we have with our own task program, the guys at Vanilla Guerrilla Security, VGS, and Ben Wallach. We have a lot of great opportunities, and we did that so people can get the training that they were arguing about yesterday in the courtroom.
Yeah, right. Well,
whether or not an AR-15 is sufficient for self-defense.
Self-defense, exactly. Well, let's get to that because that's what we want to talk about. So, for those of you tuning in, as you know, yesterday, Barnett v. Raul, one of the many challenges to the Protect Illinois Communities Act, which came out of Southern Illinois with a victory at the trial court level, was now before a 3-judge panel of the Seventh Circuit. Todd was kind enough to endure the pain and agony and sat through the whole thing. I got 6 pages of notes because I was listening to all of it. Now, I'm not going to hold you accountable for everything here, but I kind of want to start at the end because I think the big news to come from this, as far as did anything historically occur, is that we had a United States Attorney General arguing on behalf of lawful and responsible gun-owning Illinois residents yesterday, who clearly put on the record that the United States Department of Justice position is that assault weapon bans and magazine bans are unconstitutional. Yeah. Remember that?
Absolutely. And I think the other takeaway, she looked Easterbrook square in the eyes and told them they got Beavis wrong, that their standard that they are adding, this military characteristic test that they created out of whole cloth, is
out of thin air. Yeah. Yep. That's right. That's exactly right. It's exactly right. And so, again, is that going to make a difference? We're going to talk about we're going to read the tea leaves here in a minute, but I do want the viewers to understand that from a historical standpoint in Second Amendment litigation, that is a pretty monumental occasion to have a United States Attorney General in there arguing on behalf of lawful and responsible gun owners. I also noticed that the panel didn't really seem to have a lot of questions for A.G. Dillon.
No, Easterbrook peppered her on a couple of things.
Standard of review.
Right. He got him whether or not if another trial court had a different, it came up to a different conclusion. And facts. And Easterbrook is notorious for putting words in the lawyers' mouths that they did not utter.
Yes,
and
right.
He was not the bully I was expecting yesterday.
Well, let's talk about the panel, because I want everyone to understand, because the panel is important. There's 3 judges and you got to get at least 2 votes. Okay. Frank Easterbrook, who has a history, I will say is notorious for Second Amendment cases. Now, you looked it up before we went live. This guy is a Ronald Reagan appointee, appointed in 1985. One would assume he is pro 2A, but unfortunately, Judge Easterbrook's developed quite the opposite reputation, hasn't he?
Yes, he has. He was there on the panel on McDonald and was absolutely rude to our lawyer. I was in the courtroom in 2009 for that. And he's been on the Beavis panel. He's been around, and he seems to harbor a grudge that, Scalia and Thomas got to the court and he didn't.
Yeah.
And with all
maybe if he wasn't such a dick, he would have gotten there. Now, we have another justice, though, Michael Brennan, who I understand has only been on the bench for a few years. Is that right?
I believe so.
Now, Judge Brennan has already authored opinions related to Second Amendment issues, which I think are important to educate. So what's his involvement with previous Second Amendment litigation?
Well, he was a dissent when this case was up as the Beavis case on the preliminary injunction. We won our injunction in Southern Illinois. Beavis and Herrera lost up here. So there was this converge and they consolidated everything. And he wrote the dissent saying, no, the Southern judge got it right. Yeah. So with what we have so far, that's the only case I've got him on that I can think of off the top of my head. But he was a little bit more demurred in the first hearing 2 years ago. That may have been because with Wood and Easterbrook there, he knew what he had. And why am I going to sit here?
Why am I going to waste my breath on this one? This one's already in the bag for the other side.
And
but I think we could, again, not an exact science, but if we try to gauge the tone of the questionings, the tenor of his questioning, it would appear that Judge Brennan is on the side of Illinois gun owners.
He's going to have to do a 180 if he's not. And I don't see the questions he asked yesterday tearing apart the state on the standard and the test and all that. And he kept pressing.
He pressed hard.
When they wanted to veer away from the rec, well, wait a minute. We have a fully developed rec. And he kept going back to that and things. And all of that was, to me, he was and so this is the third judge was St. Eve.
Yeah, so that's a great segue because we've identified Judge Easterbrook, and we could have picked the minute he got selected to the panel. We know where Judge Easterbrook's going to come down on this issue. And I think Judge Brennan made his position very well known yesterday through the questioning. So at this point, I think the smart money is on. It's a 1-1.
Yes.
That brings us to Judge St. Eve. Okay, which those in the know prior to this, not myself, but people such as you and other people I talked to in Illinois, did not think that Judge St. Eve was going to do us any favors. No. However, I think that attitude in talking to other people, yourself included, may have changed a little bit. So why don't you tell the viewers a little bit about what you saw from Judge St. Eve yesterday in the courtroom?
So I think it's what the other judges were doing. I think Easterbrook, who's known to be a bully, to be pompous, was more. It took him 17 minutes to ask the state a question.
Yeah,
that's a lot of. They're like, we don't see that.
Right.
He's usually just out there and at it.
Yeah, right after may it please the court, and he jumps on you instantly.
Right, and I think he went in there not knowing if he had the second vote to do the stuff. At the same time, I think Judge Brennan was probing questions, playing to St. Eve to try, and St. Eve went down a couple of roads. I think she was harder on the state than she was on our guys.
I agree.
I think that, but she was part of this horrible decision in Schoenthal about mass transit, which talks about confined and crowded spaces as a whole new test out of whole
whole new test again coming out of thin air.
She was bad on Viramontes, but if you listen to the orals of Viramontes, she was very upset that there was a lack of record. Okay.
Which she has no complaint on in this case, because if ever there is a case that has a absolutely well percolated record, it's the Barnett case. It's a 160-page ruling, and the record was a 4-day trial that occurred down there?
Yes, 4-day trial. And so with all of that, I think Easterbrook, in his talk about a remand, complaining they didn't get what they told the trial court they wanted, and Aaron Murphy, the lead lawyer on this, pushed back, said, no, footnote 22, it's right here. And it may not be in the format you want, but it's here.
Yes.
And so with all that, so I think that when Easterbrook is talking about a remand, or he's talking about, well, what if we get this crazy split, or all the other, manufactured problems.
Right.
I think he was fishing to see if he could get her to bite on something else.
But she didn't seem to ever take the bait.
No, she didn't. She pushed back on the state. Well, now you're asking us to substitute our judgment for the trial court and put our own facts. It was kind of like how she was. And to me, the state seemed to be grasping. The state seemed.
Well, let's talk about that, because, the Solicitor General for the state of Illinois gets up, and I think that while we had been reading the tea leaves and going, man, we're probably going to lose this thing 2-1, I had the impression that she also thought the same thing. She got up there and was kind of just nonchalant, and of course we get to do this, and it's like an attorney who's not used to losing, which when you're an Illinois AG in the 7th Circuit, you might not be used to losing. But the minute she got pressed by both Brennan and St. Eve, almost right out of the gates, about the record and about this well-percolated, well-developed trial record and all of that, it seemed to throw her off her game. And at that point, she got almost, it seemed like she was getting desperate in ways, like creating other rules of law out of thin air right there during oral argument. What do you
she got pressed. Well, I think the other dynamic that won't come across, Brennan was on the left side of the court, Easterbrook in the middle, and St. Eve on the right side. So she was doing this, going back and forth with the questions like a tennis match. And I think that when she started bringing up, I mean, the judges caught it. And the judge, Brennan and St. Eve caught some of the stuff. And it seemed like they thought they were going to go in on an easy win, like you've illuminated. And then they got pressed, and they were flailing in my.
Yeah.
They didn't, they weren't so obviously that they were, but you could tell that this wasn't the same composed, static, whatever. It was, I think they even felt they had problems.
Well, and it seemed that she was getting desperate because she started going back to some of the things like more appropriate for military use, in common use for self-defense. She continuously tried to equate the AR-15 to the M16. They basically saying it was essentially the same thing. She got a little pushback from that as well. But she also, and this is the arrogance that we see out of the civilian disarmament crowd. And in particular, we see it out of Illinois and California. These firearms are not necessary, not useful, and not chosen for self-defense.
Bullshit.
Now here she is. Here's everyone complaining about the record. And it was like, well, the record was sufficient when it helped you, but insufficient when it didn't help you and all of that stuff. But that is a finding that is contained nowhere in that record.
Right. And the other part of it is, I mean, I guess what I really want to do is I want to take a bunch of these lawyers, bring them out to the club and run them through some stuff for a couple of days. Cause you were through the shoot house with me doing some stuff, you know, and saying, this is all we train on. I mean, at our zombie shoot, there were 426 shooters out there and they were all practicing with these types of firearms for self-defense situations. And what I really wanted to scream from the bench is, for 30 years, Chicago had a handgun ban, and you said we could have rifles and shotguns. Now now you're telling us, well, we could have handguns, we can't have rifles and shotguns.
Well, yes. And of course, let us also remember that when the Seventh Circuit had the opportunity to do balancing tests, they always found that the Second Amendment applied, and then that there was just an interest that outweighed the individual. Then when the Bruin test comes out, suddenly the Second Amendment no longer applies to these items at all. So
no, and then they start trying to rewrite the test by redefining arms. And they're making all of this up out of whole cloth.
That's right. That's right. Do you believe that there is a chance that the two of those judges, because we know where Easterbrook's going to come down, could be just say, listen, the record is very well developed. The findings of fact are such that, it has to, the only way you overturn a finding of fact is this, a finding that's just so unreasonable, no other person would have made the same finding. And based upon this record and the applicable law, the judge at the lower court made the right call. Do you think that's a possibility where they could really just rely exclusively on the record?
I think there's a possibility. I walked in there expecting, we're going to lose. Just hope they write the opinion fast so we can get on.
So we get on with it. Yeah.
We are now gaming all kinds of different scenarios because we walked out of there with hope and the possibility that to me, I'd rate it at a 50-50 coin toss now, not knowing.
I think that's a fair assessment, Todd. I do. Let me ask you this. When they got finally beyond step one of the Bruin analysis, and we're now into the history, the Solicitor General for Illinois consistently said the plaintiffs have offered nothing. The plaintiffs have offered nothing. Even when we sent it back, the plaintiffs have offered nothing. Now, I thought that the rule of law was that the burden of proof lied with the state. And I was a little disappointed that no one, either on the bench or at counsel table, pushed back on that notion. What do you make of that?
Brennan actually did.
Did he?
Brennan sat there and said, but isn't this a high hurdle for you to get past? Well, because they went into, they were the two things they had were trap gun laws, which are booby traps, not speed.
And I thought that the other attorney,
Tom Mag,
Tom did a fantastic job of explaining that, by the way.
Yeah. And yes. And then the other part was that they talked about Bowie knives, and Aaron, I thought, did a very good job of pushing back, saying, hey, wait a minute, and you've only got 3 or 4 or 5 of these things. And the Supreme Court has kind of said that's not enough, I think that when they were talking about some of the other laws, the state kept trying to drag in the NFA and go to 1930.
Right. Which again, Mr. Mag did an excellent job of saying, but the NFA is not a ban on these items. It's just a taxation and registration scheme.
Up in the 1930s, it was not until 1986.
That's right. Firearm Owners Protection Act. And that only dealt with fully automatic weapons, because all the other items still remain highly regulated, but legally obtainable under the NFA.
True. And so the cap on civilian ownership of machine guns was put in '86. And you and I have had conversations about how to attack the Hughes Amendment, to which comes first, the chicken or the egg.
Right.
But no, but they pushed
Let's
back.
get through magazines and ARs first, Todd, and then we'll move on to the automatic weapons.
Well, for whatever reason, they seem to be enamored with talking about machine guns in court yesterday.
Well, that's because the state of Illinois was attempting to equate a semi-automatic rifle with a machine gun. That they were tantamount to each other, which they clearly are not.
They are not. And there was a lot. I thought this hearing went much better for us. And as we're looking, but they had trap guns and Bowie knives.
Bowie knives, yeah. And
our guys pushed back on that and said, "Hey, no, that's not the same." And Brennan pushed back and was like, "Do you have anything else on a weapons ban?" If I recall, I mean, there was some pushback that that's not enough, and don't you have a high burden or a high standard to get across here? Yeah. And they and it wasn't said implicitly, but and you want to, the burden's on them. The burden's not on us.
That's right.
They keep trying to flip this thing. And it's like, for the love of God, it's not on us.
Well, speaking of burden flips, let's talk about this, the whole dangerous and unusual in common use, because if the state of Illinois had it their way, and again, this is an argument that's been, as you said, created out of cloth, I say pulled out of thin air. The Solicitor General for Illinois argued that particularly dangerous firearms, whether they're in common use or not, can be banned. And she flat out said that because she doesn't want to have to just deal with the counting exercise that is common use. Now, she got pressed on that by Judge Brennan, and she appeared to back off of it a little bit. But what do you make of the – and one of the other things is she said, hey, this particularly dangerous standard's been used by other circuits. So what we have these circuits out here creating this new fictional rule of law, and then they cite to each other as though it's actual authority. What did you make of that?
Yeah, and they're trying to muddy the waters because they were playing to Easterbrook's comments in the Beavis decision about the common use as a circular test. And if you read the New Jersey briefs, the state is trying to force our side to pick a number. Well, we don't have to pick a number, because if you simple thing, under the Illinois law, braced guns are banned. All right. They qualify as handguns.
Yes.
Heller said handguns are protected. Did not delineate between a Derringer, a muzzleloader, a revolver, or a Glock. Handguns are protected facially at first step.
Full stop. Yep.
So these are handguns or pistols under the category of ATF. We know from ATF there are between 3 and 7 million in their estimate. By the Congressional Research Office, there are 10 to 40 million of these, braced guns around that they tried to requalify as SBRs.
Yes.
It doesn't matter if it's 200,000 in Catano or not. We're in the millions. And I don't think that any reasonable person can say that when you are talking about, and we haven't even brought in Glocks, we haven't even brought in the ARs themselves,
right.
And that, there it is. And then when they get into this, I think that's where the state tries to do this interest balancing about dangerous.
That's the thing, because any of this, is it more appropriate for military use, or is it in common use for self-defense, or is it appropriate for self-defense? That is judicial balancing again. And now what you got is you get all these judges, many of which, and you can tell by their opinions, have no knowledge of firearms whatsoever, not even basic functionality of firearms. And now we're allowing them to determine what we should be able to use to defend our lives.
Yeah. And that was one of the neat things about McGlynn. He knows guns. How many, should I have her grab the shotgun that holds 3 rounds? Well, if you're not hunting, you don't understand the game laws to where you have to put a plug in your typical shotgun. Most guys don't know that. And, he was even asking a lot of probative questions from the bench of the experts when we were in the courtroom with Judge McGlynn. So, the state is trying to weasel interest balancing back in under a different night.
Well, and so are all the circuit courts. You're seeing these circuit courts, the 1st, the 3rd, the 4th, the 7th, the 9th. They're injecting this back in with this more appropriate for military use, in common use for self-defense, whatever the other, made up rule of law du jour is that day.
Yeah.
I got to ask you this question, and then we're going to move on to Miss Murphy on behalf of the Barnett parties. But there was some questioning about the registration requirements
at the end
of the Solicitor General. And her position is that if the state prevails on the AR and magazine stuff, we win on everything. I was a little dismayed that there was no question from the bench, nor from Miss Murphy when she was arguing on behalf of the petitioners, because she too was asked about this, that registration requirement is in violation of federal law. The same law, by the way, that we already talked about, which banned machine guns in 1986, is also the Firearm Owners Protection Act, which says no state or federal resource can be used at all in any way, shape, or form to create a gun registry. Yet, isn't that exactly what the state of Illinois has done?
Yeah, it is. And that's where we go back to the state grasping at straws, because the state has been arguing about severability, that the judge threw out almost the entire statute because this part can't stand without this. And they say, oh no, registration's different. And Aaron Murphy came out and said, look, the only reason this registry exists is to show that these individuals were grandfathered in under that clause of the act. And if the gun ban goes away, there's no reason for these people to do that. There's always the things that get missed. And I'll stick up for Aaron that in all the conversations we've had and the stuff that the lawyers, everybody was going in there expecting a very different fight. We were ready to be, to do the rope a dope.
Well, you and I had talked about some of the preparation going into this, and I know that the preparation was this is going to be a Donnybrook of a hearing, and then it turned out to not really be that.
Yeah, and no, it was way more civil, and I think it was way more, it was more balanced. I mean, even, win or lose, you're always, as a gun guy, frustrated by what the judges don't know that they're supposed to rule on a subject matter like this. And that's one thing, but at least it wasn't as over the top as some of the Fourth Circuit stuff has been, some of the Ninth Circuit stuff has been. It was very balanced in the way that it went on, which that's what we were all like, what did we just watch?
Let's talk about Miss Murphy, Aaron Murphy, who argued predominantly. She had the majority of the argument for the plaintiffs, Barnett and the other named plaintiffs. Now, I understand that Miss Murphy had also argued in the Beavis v. Naperville case.
She did.
And the reviews I had gotten out of that, and again, I'm not commenting on Miss Murphy's ability, because having done these arguments, sometimes you can get so thrown off your game. You can prepare for one thing and get something else. But what I heard from a lot of people familiar with both arguments is that Miss Murphy did a bang-up job and maybe had learned quite a bit from her experience doing the Beavis case too. Did you have that same takeaway from that?
I think Aaron's gotten much more seasoned on the subject matter that she's done. I think she did an argument out in the Ninth Circuit. I think she's had 4 or 5 under her belt since Beavis. And I think that, she, no panel's the same, but I think she did a very good job. I was happy with the way she handled the question. I think she is a little bit, I can say things because I'm not a lawyer and I'm not practicing in front of the court. What are they going to do to me? She's from a very respected law firm.
Yeah.
And she clerked at the 7th Circuit.
Yeah.
And so I think that she knows some of those personalities, and she has a different, it's like somebody walking into the legislature when I was there and pounding on you. This is what you don't understand the dynamics in here.
Right.
So I think Aaron understands the dynamics of the 7th Circuit very well. And I think she put a good foot forward yesterday.
I agree with that assessment. I want to go through a couple of things. There was pushback. I can't remember if it came from Judge St. Eve or if it came from Judge Easterbrook about the fact that these firearms are used in criminal activity. Of course, you can go across any platform of firearms and find that they're used in criminal activity, handguns being the most prevalent, by the way. I think she did a fantastic job of pushing back on that. What was your impression of that?
Yeah, she did. I mean, basically St. Eve was trying to bait her into some interest balancing, and she didn't take the bait.
Well, Barry Arrington in 2 different amicus briefs, one in the Gators Guns case out of Washington, the other one in the Duncan case, I think is framed it well, which is the potential abuse of freedom is the price we pay for that freedom.
And if all we're ever going to do is let the misusers of freedom or rights negate the rights of the rest of us, then what do we got? Nothing.
Yeah.
And so, I think that's a problem and I think goes right to the heart of the interest balancing that Scalia tried to outlaw in the Heller decision.
Right.
And
sometimes Thomas tried to do it a second time in the Bruin decision too. And here we are still talking about it.
They quoted Heller again. And sometimes I just want to scream that quote. It says, we know of no other enumerated constitutional right subjected to a freestanding interest balancing approach. The very enumeration of the right takes out of the hands of government, even the third branch of government, whether the right is really worth insisting upon.
It's very obvious to me, Judge Easterbrook had a line of questioning, and it really had to do, and towards the end of Ms. Murphy's comments, they really started pushing back on the class of plaintiffs who would be entitled to relief.
Yeah.
And Judge Easterbrook went into a long diatribe about Trump v. Casa, which for those of you who don't geek out on that stuff, that is the case that says district courts do not get to issue nationwide injunctions. And for some reason, he believed that the court in Illinois was therefore incapable of issuing a statewide injunction. Was that just Easterbrook just venting about a case he doesn't like, or does he honestly think that a court in Illinois cannot issue a statewide injunction in the state of Illinois?
I think he's fishing again, trying to see if there's something that St. Eve will bite on. But you just illustrated the problem. What you had district court judges impacting a national policy across the entire country. Here
and oftentimes usurping the power of the executive branch too, which is a big problem.
So you had you got an Article 3 problem, and Article 1 problem too, and all that, right? But on the other side of it, here you have a judge. He's not telling the people in California anything. He's not saying anything about the people in Iowa or Texas. He's pushing. He filed for an injunction that was within the confines of his jurisdiction.
Yes,
and I think Easterbrook. It was this one. It was some of the other stuff about other district courts where he was trying to be that gotcha law professor.
Yep.
To stump the third-year law student.
The thing, which I have experienced that on multiple occasions back in an earlier life.
That's what I thought he was doing. And I think part of that, maybe I'm reading too much into this, but would it be reasonable to infer that was his sense of losing control of where the case may be going, that he's trying to latch on to anything or get something out there that tips the scale?
Yeah. Real quick, there was another gentleman, Thomas Magg, I believe was his name. And he only had a few minutes, and his style of presentation was definitely much different than Miss Murphy's. I think he was he's much more of a relatable person, is how I would put it. He uses real normal, simple language.
He's a small town lawyer.
He's a and he talks like a small town lawyer, which is a compliment, by the way, not a criticism. He clearly knows firearms, however, though. He knows firearms really well.
We had a couple of long conversations in the hallway while we were waiting for court to open. Tom knows things about firearms. He really does.
And I thought that, and Tom, if you're listening, don't take this the wrong way. When he got up and first started talking, I was kind of rolling my eyes like, what is this really going to contribute to the argument here? Okay. And then within about a minute, I'm sitting there going, Oh, no, those are really good points he made. And by the time he was done, and I should point out, not a single question was asked of him by any member of the bench. I thought that some of the naivety that we get about the functionality of firearms had been really, really cleared up by him. And I thought that his 5 minutes in front of the microphone actually turned out to be a pretty important 5 minutes.
Yeah, he, you know, when the state was arguing about trap guns, oh, there's these trap guns. Trap guns are not a ban on firearms. You could have that shotgun. What you couldn't do is you couldn't set that double-barreled shotgun up to be a booby trap that was indiscriminate on who was going to get maimed.
That's right. And we ban them here in this state. We call them spring guns, but spring guns are banned in Washington State as well. Coyote getters. Right. That's also one. Yeah.
So, you know, he illustrated, he said, you know, when people hear trap, they think about shooting clays. That's not what we're talking. That's not what they're talking about. This is a booby trap. And he used those words. And then he also elicited that, you know, as everybody was talking about, and they tried to bring the NFA in at one point. We looked all the way up to the 1930s. You're not allowed to do that. You're barely allowed. It's unclear you can get past 1868. But in that, with, you know, he said the NFA was not a ban. There was no ban. As far as the feds were concerned, it was a taxation scheme, and the registration there
for tax record keeping. That's the only reason the registration was there. Slozinski tells us that.
Yeah. So, you know, and much like the registration scheme under the Illinois gun ban is for the grandfathered individuals, and it serves no other purpose. So yeah, Tom, he took a little bit of time to get there.
Yeah.
But he usually has something to add. And you know, it was, I enjoyed talking to him in the hallway. We had a good conversation after it, and everybody, oh, I should have said this. I should have said it. You know, like you said, if you're not in the ring having to have all this stuff in front of you and getting bombarded with these questions, and then a judge tries putting words in your mouth. I didn't say that. It's not my argument.
Yeah.
And no, it's not my argument. You know, so I can understand where it's frustrating.
Well, let's talk about a couple more things, and then we're going to wrap it up. Number one, if the state of Illinois prevails and the ban is upheld, where do you believe the plaintiffs go? They petition straight to SCOTUS at that point?
Yes. There's no purpose for us to go en banc.
Absolutely done. And as we were talking off record before we went live, there's some internal rules within the Seventh Circuit that really discourages en banc petitions.
Yeah. So I can't think of a reason for us to go en banc. We want to get to SCOTUS as fast as we can. I'm hoping.
So you believe that the plaintiffs here, if they do not prevail, will prepare a petition to SCOTUS almost immediately?
Yes.
Okay. Now, if let's say we get St. Eve and we win 2-1, which we'll get to that in a moment. I would anticipate that even though the Seventh Circuit says they don't like to take en banc reviews, the state of Illinois will ask for one before the ink is dry on the order, and it would probably be granted almost immediately with a stay pending that outcome. Would you agree with that?
I didn't understand the last part. I don't know if they would prevail in the vote for the en banc panel yet. It tips their way, but the Seventh is not notorious for granting en banc.
Right. So unlike other circuits that are.
So, you know, I think there's like 2 weeks for them to vote. So, and the state asked for an en banc review of our Kerry decision back in 2013 and did not get it.
Okay.
So
there's a high probability that the next place that this case, Barnett v. Raoul, is going to pop up is going to be before the United States Supreme Court, regardless, because, you know, the losing side is going to have to appeal this.
Well, so there are a couple of scenarios. One, we prevail. Does the state want to go up to the Supreme Court? Because if the tea leaves are what we think the tea leaves are, and this is the case they want, you know, it's kind of like when we won Kerry. Bloomberg's people talked to the AG's office and said, hey, you were the last state to pass Kerry. We've only lost Illinois. If Wisconsin had Kerry, Indiana's had Kerry for years. If you guys go to the Supreme Court, we lose the nation. And it could have been brewing, you know, 12 years ahead of
12
that,
years
right?
earlier.
Whatever.
Yeah.
So there's that. My
Right.
biggest fear is a split decision, that we win some, we lose some.
My biggest fear is that with all this talk about the record, that they turn around and remand the darn thing back and age this thing out like fine wine.
That's another one. But you know, for all the complaining they did in the Viramonte's case about a record, and then if you jump back, I think it was the Anderson case, which was one of the first nonviolent felons to go up in front of the court. And if you go back, they were all but asking the state, the feds, ask for another chance to do some more briefing. And they were trying to lead him there, and the guy wasn't drinking the water. And so I think that, they remanded in the felon case because there was no record. Viramonte's, they just ruled against us and said, no, don't go get a record. It's summary judgment. We're done. And that, so it's a possibility. I don't know that I think that because Brennan made a big deal out of the record, and St. Eve made some comments about the depth of the record.
They were, two of the three judges seemed to be very pleased with the record that had been developed.
Yeah.
Yeah.
Yes.
Okay.
Yes.
Here's my final question. You ready?
Yep.
Big final question. What's your prediction? And I'm not going to hold you to it because, listen, we're trying to read tea leaves and, speculate here. But what's your prediction?
As much as I would like a win for the circuit split, I just have, and I'm truly 50-50.
Okay.
Somebody could point something out that somebody said, and I hadn't thought about that. If they're going to overturn a ban at the appellate level, this is the case to do it. I'm just not convinced that St. Eve is there yet. And she's got two. Now, maybe she's going to surprise us all, or we're going to get this horribly bifurcated magazines, no guns yet, or only AR-15. I don't. And is there that kind of horse trading that goes on in the back room with those guys?
I haven't spent a lot of time back there with.
Yeah,
them,
no. So I really don't know. I mean, I think that, and earlier you had made the point about the Department of Justice coming in on this case. And if we get to the Supreme Court with this, then I would wager that the Department of Justice would be filing another brief with the court. And if they do that, I was looking at the miscellaneous orders on the court's page this morning. Mm-hmm. The other day there was miscellaneous orders, and the Solicitor General won 5 of his requests, 5 for 5. So that would mean that if the Solicitor General says, please take this case, and to, ask for time, that it would most likely be granted. I mean, that's the backhanded importance of the DOJ coming in.
Yeah, people just really cannot and I know that people are flip-flopping on Pam Bondi all the time, and some people are hot on her, some people are cold on her. But when it comes to this issue that you and I are focusing on, there's been a remarkable change in atmosphere with DOJ as it relates to Second Amendment rights.
It's a seismic shift.
It is a seismic shift, yes.
And, even them coming out in the suppressor stuff. I mean, I know, I wasn't a big Bondi fan in the beginning, we all haven't been, thrilled with the new ATF director or whatever and all. But you know what? Overall, this administration has done us, a few solids here.
They've done more good for us than they've done harm. That's for certain. Yeah.
Right.
All right. Last question. For anyone, especially in Illinois, who's living under a rock and they haven't heard about Freedom Steel, why don't you tell us a little bit about how can people subscribe to Todd Vandermyde's Freedom Steel channel? Because I checked you out and I think you do a fantastic job.
Look up Freedom Steel on YouTube. It's my channel. I need to put more content up there, but when I get done with you, I will be putting on my boots and going to get on the club's bulldozer to work on grading out that 200-yard range you saw me working on.
Yeah.
We're trying to get all that up and going before the snow flies here. We got one run of storm sewer in, but Freedom Steel started off with me doing dirt work at the club. and it's a play on words that we're using heavy iron to sit there and build a gun range so we can exercise our freedoms. And so with it, it's my YouTube channel. It's my take on how I look at things, and it's always a pretty good feeling to have guys like you who are vetted lawyers who have been doing this for a career turn around and say he's onto something, or I agree with what he's saying.
Your legal analysis is really, really thorough. It's like I said, I think you missed your calling. Well, Todd, listen, I want to thank you a million. And not only do I want to thank you for hopping onto the channel with me and sitting there and enduring all of that in the courtroom yesterday, but like I told people at the very beginning, you have always been my go-to Illinois guy. I think I have probably covered Illinois as much as any state, including Washington State, because y'all give me so much material.
You've got a good following out here, Bill.
I do, and I love the and you know, here's the thing, and I know we got a lot of folks from Illinois out there. And first of all, I want to thank all the folks in Illinois because y'all have treated me really, really well, and I really appreciate that. I've also had a chance to go out there a couple of times, which has been awesome. And I find that our states are very, very similar, which is, you know, when you're in Cook or Lake County, you just think it's just a progressive hellhole. Just like when you're in King County or the Puget Sound region here in Washington State, you'll believe it's a progressive hellhole. Then you get out of there and you get to central or southern Illinois. Just like when you get to central or eastern Washington, you realize, no, there's just a bunch of hardworking, red-blooded, God-loving Americans out here. And so I think both of our states kind of suffer from the same ailment, which is this one large metropolitan area that's completely screwing it up for the whole state.
Well, that and a Republican Party that can't find its way out of a wet paper bag.
That is a prevalent problem.
You know, I mean, that was the thing with Charlie Kirk was doing what the local GOP should have been doing. That's a subject matter for another thing. But, you know, and dude, when I saw you on that one video about mass transit, and oh, that's my highlighted copy. I said, when you're holding it up, and I'm giggling. It's like,
and I told everybody that you sent me it. I was like, hey, he highlighted it for me too. So he cut out about an hour worth of homework for me. I appreciate
it. That's how I got to be an effective lobbyist, because I'm not a lawyer, and I was arguing against lawyers, and I had to know our subject matter better than theirs, and I did. And being able to take stuff and put it into a relatable format, just like you do. We try to boil down these very complex things. The mass transit ruling, I think it is one of the most dangerous rulings.
Yeah, because any place where a bunch of people are present.
And kids. And how we'll never win another sensitive. And that's why I hope those guys are preparing a cert petition. And I think every major gun group that, because that was an SAF case with the state association. Every other major gun group should be doing an amici for cert because of just how dangerous. And it's another new test made out of whole cloth that is nowhere in Heller brewing anywhere. Right. Not even Rahimi. Although Rahimi did come up yesterday.
It did. You know, I had that in my notes. It came up, and the attorney general for Illinois said, well, we win with or without a nuanced approach. I'm glad it didn't come up with a whole lot of frequency during the argument. However,
I think it came up maybe twice, and it was largely brushed aside.
Yeah,
I think that Tom Mag did better on his part of it than the state did on their part when he took apart their argument on trap guns. These are not the same. The Bowie knives are not the same. You know, McGlynn even said, no, that's Bowie knives. That's not carrying a gun. And I think that's why I think the state was struggling. I think they thought they were going to get a layup, and they didn't. And their extraneous regurgitation of the same old BS wasn't flying for them.
That's right. Well, Todd, my friend, you are a champion for Second Amendment rights, not only in Illinois, but nationwide. Keep up the great work that you're doing. And thanks so much for taking time out of your busy day to hang out with us. For all of you who decided to geek out with us today, thank you so much, especially all my friends out there in Illinois. I will talk to Right to Bear about trying to get back out there in the springtime. And I have already talked to him about starting in the southern part of the state and working my way back up. I just haven't gotten down to, and hey, listen, you know, the original Kirk homestead, the first Kirk to live in the United States of America, had a farm outside of Springfield. So I got to get down there and see where we all come from. But Todd, thanks a million for being here. I really appreciate it.
Hey, thanks for having me on, Bill.
All right. And everyone else, thank you so much for joining us. Hey, check out our video today. We did a quick video about, as you know, President Trump yesterday designated Antifa as a terrorist organization. I'm not opposed to any of that. In fact, they're indigenous to my area here. So I'm actually a big fan of that. The problem is I don't think the legal framework is there for the president to do it. So check that one out too. Todd, all the best. Give my best to your lovely wife too. And we'll talk soon.
Frag out.
All right. Take care, brother. Bye-bye.